Hello all, my name is Ari Redboard. I am the head of legal and government affairs at TRM Labs, the leading provider of cryptocurrency fraud detection and anti-money laundering software. TRM Talks is a monthly discussion with policymakers and business leaders in the cryptocurrency space. Welcome to a special breaking news edition of TRM Talks. The 2021 National Defense Authorization Act, the NDAA, contains the most significant anti-money laundering legislation in decades and signals a seismic shift in the relationship between law enforcement, financial institutions, and regulators. Not only does the NDAA require businesses to provide critical beneficial ownership information to regulators, but the legislation redefines currency to include crypto for purposes of its anti-money laundering regime. What does the NDAA mean for cryptocurrency space and for your business? TRM talks today to former Treasury Deputy Assistant Secretary for Legislative Affairs Andrew Eck and crypto legal legend Carol Van Cleef about what the NDAA means for crypto. Welcome to you both, and thank you so much for joining me today. Carol, let's just go ahead and dive right in. Before we sort of get into the implications to the crypto world in terms of the NDAA, can you provide an overview of the AML provisions? I mean, what's in this thing and what's all the excitement about?
Well, I guess let's start with the bill itself is 4,500 plus pages long. And as you said, this is probably the most significant piece of legislation in decades, at least 2 decades. And there are approximately 250 or so of those pages are related to AML. It's almost as large as, or maybe larger than, the package that passed in the USA Patriot Act. Which really turned the world upside down in anti-money laundering compliance. So from the perspective of crypto, I'm going to start by saying, I don't think you will find the word crypto used in the legislation, but you will not find it anywhere referencing cryptocurrencies. The references, at least the ones I saw, maybe you saw some others, related to cryptographic uses in the defense industry. And the technology infrastructure of the United States. So I think that's an interesting starting point. So as a lawyer, typically when you've got a massive piece of legislation like this and you want to know, how it's really going to affect you, the first thing I do is the keyword search. So I tried the crypto, and as I told you what the results were there. Virtual asset, or virtual. So I used the term virtual because I put in currency initially and it didn't quite play out the way I wanted to. But I put in virtual and I had about 40 hits, of which about 11 related to the subject matter we're talking about today. 10 of the 11 were virtual currency and only one of them was virtual assets. So that's a little bit telling. And then when you start to look at how the term was used and where it was used, it was only used in sort of what I would say the fluff piece at the beginning of this whole section, which is typical in legislation, is here's why we need this new piece of legislation. And virtual currency was mentioned in there, but nothing that would impose any kind of legal binding, any requirements on the crypto industry. The second place that we saw the term being used was in the context of a couple of studies that have been commissioned by of the GAO. The significance of that is that these studies will help lay out a legislative agenda in the coming years. And clearly, the focus of that legislative agenda ahead is going to be cryptocurrency. Now, having said that, that doesn't mean everyone can take a deep breath at this point. Far from it. There were some very significant changes to key definitions in the Bank Secrecy Act, which are going to have extraordinary and long-term implications for the crypto space. Now, again, I may have just overstated that slightly because a number of the changes that were made, the definitional changes, and I say a number, there were only a handful, are really putting into law principles that had already been established either through court decisions, judicial decisions, or by guidance or other statements coming out of FinCEN or elsewhere in the government. So that's an overview, and we can take a deeper dive. But I'd love.
That's fantastic. That's perfect, because there is so much else I want to talk to you about in terms of what's in there. Andy, you were the Deputy Assistant Secretary for Leg Affairs that really handled all the TFI matters, terrorism and financial intelligence at Treasury, which, for those listening, is really the entire national security apparatus within the Treasury Department: OFAC, FinCEN, TFFC, OIA. So you really had a front row seat to these AML issues, beneficial ownership in particular. We would love to hear a little bit about the sausage making. This has been a long time coming. There's been legislation in the works for a very, very long time. Can you talk a little bit about that process and sort of what it looked like from your perspective at Treasury?
Sure thing. Thanks for having me today. Good to see you, Ari. One of the most interesting parts is the sausage making and kind of the behind the scenes work and how we got to where we are today. This was a long process to get to where we are today with the NDAA and the various AML, BSA provisions in it. The BSA, of course, was originally passed back in the 70s, and it hasn't had many significant updates since then, for about 2 decades since the Patriot Act was passed. But there's various dollar thresholds in there that have not been updated for inflation, and just all of the kind of nuts and bolts mechanics of how the reporting regime operates really has not kept up with technology today. So there hasn't really been a sweeping legislative update for the past 2 decades. But to kind of get where we are today, I would say some of that started a number of years ago when the House Financial Services Committee stood up its first subcommittee dedicated to terrorism and illicit finance. And I had the honor of running that from a staff level. And a lot of what we did was really heavy on member education. We had over 100 briefings for members of the committee from all sorts of private and public sector stakeholders to hear about just about every aspect of the Bank Secrecy Act and what should be updated. We had over a dozen public hearings that we heard testimony from all sorts of public and private sector experts. And so a lot of those issues became individual standalone bills that members introduced several years ago. And a number of those over the past few years were tweaked and edited from. There was a big lobbying push on both sides that we can get into, but they're ultimately incorporated into this year's NDAA, which has passed the House and Senate, of course. So I would break this year's NDAA into kind of 3 big components of AML and BSA issues. The first of which gets probably the most attention, is beneficial ownership, which has been really a long time coming. The second are the updates to the country's AML and CFT regimes. And then the third bucket I would put it in are updates to Treasury and its Office of Terrorism and Financial Intelligence authorities to oversee AML programs. So first of all, kind of the background on beneficial ownership. Congresswoman Carolyn Maloney from New York, she's been the champion of beneficial ownership for years. She's introduced her bill for well over 10 years. And in her district in New York, she first came aware of the beneficial ownership loophole from all the condominiums in her district and how no one lived in them. And so it was shell companies buying these up, some of which were for money laundering vehicles. And so she really became a champion in really just for the country to close this loophole of not having a beneficial ownership registry and not collecting beneficial ownership when companies are incorporated, because Treasury and FinCEN specifically did what they could to close the gaps within the administration when they formulated the customer due diligence rule, or CDD rule, which requires banks to collect some information on their customers when they open a bank account. But the lagging part was there was no such requirement for when a company incorporated to say who their true owners were. And the United States was repeatedly dinged by the Financial Action Task Force and other intergovernmental international bodies. So it really was a win to get beneficial ownership done. And it's going to be differing for some other databases in other countries. FinCEN will hold this data. It'll be a private database. It'll be accessible to law enforcement and banks with customer permission when they want to confirm information. The second bucket.
Actually, Andy, before you get to that second bucket, let's stay with beneficial ownership for a minute. It is just transformative. I mean, as you know, I think there are two sides to this, right, Carol? I mean, I was a federal prosecutor for about 11 years, and the more information that regulators and then law enforcement have, in my mind as a prosecutor, the better. But at the same time, obviously, there are burdens that this creates on business and potentially the crypto industry. Essentially just really as businesses who may have to provide, information related to all of this. Can you talk a little bit about sort of how you see beneficial ownership, really maybe on sort of both sides of that?
I'm glad you asked the question because I think it's important to point out that the beneficial ownership provisions that apply today that went effective a couple of years ago don't apply to the crypto space. The crypto space does not, at this point in time, for if you're operating a virtual currency exchange or virtual asset exchange, you're not required to do the same. You're not required to do by law the same level of due diligence that a banking organization is required to do. So I think that's an important point to note from the outset, and I think it remains to be seen if and when these provisions are made applicable to the money service businesses, which virtual currency businesses have, I guess, in the last 8 years, and we call that have historically been called. So that's important. Now, what's interesting is you start to overlay the BitMEX indictment. And again, I'm not sure that people really fully understand the implication of the BitMEX indictment is that if you have a virtual exchange that is offering anything that looks like a derivative product, the feeling was that kind of entity should be brought in under a different regulatory regime. And that regulatory regime, in fact, does have the beneficial ownership provisions apply to it. So, we're going to get some backdoor ways in. So I'll leave it there for now. But I think this beneficial ownership under these provisions, how it applies to the MSBs and the virtual exchanges remains to be seen. However, and this is an important however underscored a few times, is that there's still an expectation of best practices. And best practices say, hey, you probably should be getting information on beneficial owners.
Sure. I was going to ask you in a few minutes, once I get the rest of these buckets, I was going to ask you sort of how you advise clients. I think you're sort of getting there, right, in terms of, best practices in an area that may or may not be a little gray right now. For sure. No, that's terrific. Andy, I interrupted you going through these buckets.
Yeah, I'll finish up the last two. The second one that I think folks are most interested in are kind of how the updates to the AMLCFT regime that financial institutions and all sorts of companies will be working with. One of the biggest areas that has been long advocated for is more information sharing between the public and private sector and more feedback from law enforcement to financial institutions, particularly when they file SARs. When I was on the Hill, the number one issue in this space that I heard from the banks was we submit tons and tons of SARs. We never hear a peep back from the government if it led to any kind of indictment, arrest, any kind of investigation. Was it useful? And so now there's various parts in this bill that do improve on that feedback. There's also areas to streamline the SARs and the CTRs, the actual forms themselves. They're going to review the thresholds to possibly update them for inflation for the SARs and CTRs, which haven't been updated for years. For some of the sausage making, there have been bills introduced in the House and Senate that would have updated those monetary reporting thresholds, but those never came to pass. There's various emphasis on fintech in the bill. Their Treasury is going to do an assessment on the use of financial technology in AML programs. And then there's various pilot programs to let financial institutions partake in, one of which, an important one, is the ability to share SARs within a financial group. which previously banks were not able to do. So that has been a long ask from financial industry, as well as for the smaller banks out there. They're now able to share compliance resources amongst themselves, because whereas larger banks, of course, have large compliance staffs and large budgets, your smaller banks and community financial institutions just don't have the resources to focus a lot on compliance. So they're able to pool some of those resources. And then real quick, the third bucket, I really like to focus on Treasury's capabilities, and particularly TFI. And there's going to be a lot of rulemaking by the Treasury Secretary and by the FinCEN Director, one of which is they're going to be setting public priorities that the private sector should kind of be on the lookout for and try to guide their AML operations. They're codifying the FinCEN exchange, which really helps with that public-private communication. And there's going to be expanded attaché programs, both domestic and abroad, to embed Treasury folks, both within foreign financial intelligence units, so the equivalents of FinCEN abroad, and within financial institutions, as well as broadening the companies that fall under the BSA now. So antiquities dealers are going to be included for the first time as potential misuse of their value. And they're going to study the arts industry as well. But overall, the NDAA, it's been a long time coming. It, of course, starts in the respective House and Senate with the Armed Services Committees. All of their subcommittees hold hearings. And then the full Armed Services Committees mark it up, pass it. They go to their full chamber. And then that's when the amendment process starts. And then the floodgates just open because everybody wants to get their amendment on the NDAA because it's this must-pass vehicle. And there are hundreds of amendments filed each year, the majority of which are just rejected right away. But it really is an impressive legislative undertaking to see just all the committees and folks that are involved in the NDAA each year. I mean, Senate Banking Committee and House Financial Services are very involved in these issues we're talking about today on what really gets attached to the NDAA, and now that once it passes the House and Senate, and then it went to the conference committee, they passed that, and that conference report is what has passed out of both chambers now to finally get where we are today.
No, that's terrific, and I've got a couple more process questions, but Carol, what strikes me about a lot of what Andy's saying right now, to some extent, is that we're still in sort of the old guard money laundering regime, right? Anti-money laundering regime to some extent, right? We're building our SAR database. We're asking financial institutions to report to FinCEN and elsewhere, to regulators. And I think to your point earlier, like there might not be a dramatic impact on the crypto space with basically just bolstering kind of the old regime that we had before to some extent. What are your views? I mean, will we need different and completely different legislation down the road to sort of deal with the impact of crypto?
Wow, I was fine up until that last question.
Yeah. Forget the last question. Go with the first question.
So let's start. What are the implications right now?
Yeah.
And I think to a large extent, it's going to be on the margin. If a company has a well-developed AML compliance program, and that means not only having the policy and even having written procedures, but has really taken to heart what they're doing. There are going to be some tweaks that are going to be necessary. And in fact, I'm doing a training for my clients this week on sort of updating their compliance program, because God knows this has been the busiest year, I think, ever in AML compliance. The flurry of activity out of FinCEN alone, and in addition, what we've learned from some of the indictments has been huge. So we're trying to just sort of get our hands around that and make sure that the compliance programs are up to date for what's already happened, much less, what the world's going to look like in 3 or 6 months or so. I thought what might be helpful. So to your point, in terms of future legislation around crypto, I think the definitional changes that were made here probably are enough of a tweak for the time being. And I was encouraged by the number of provisions talking about the use of technology and actually using blockchain technology for good in compliance. So I think those are positive takes on it. Will we be in a process of more tweaking in the future? Obviously, there's always going to be more tweaking. But I think there are a number of provisions that Andy just went through that I think may be worth a little bit of translation for the crypto space. So I don't know whether you want to jump into that now.
No, I think that's perfect. That's terrific. Yeah, no, that'd be really helpful.
Okay, so I think I wrote these down correctly. And my note taking is not the best. So Andy, you may have to help me in going through that list of items. As we said earlier, the beneficial ownership provisions is very big news. It's going to close some gaps, and I think Andy summed it up well with the stories that the New York Times in particular has run over the last several years about ownership interest, and we've seen some of that play out in the 1MDB case, and I think some of this is going to play out in some other cases that we're all expecting to come in the not too distant future. So that's one that the full impact of that on the crypto space is a bit of a question mark. I guess one of the questions I'd have for Andy is, what are the anticipations that that database that's going to be built by the federal government is going to have the access to it's going to be limited. Will the crypto companies get the opportunity to get access to that to help them in their efforts, even if they're not fully subject to beneficial ownership provisions? So I throw that one out for people to be thinking about and talking about. This is a little bit of probably of lesser importance immediately, but this antiquities provision, expanding the range of actors on antiquities. Well, that's just we've already added some of that to the red flag AML compliance regime and looking for some of that activity. But I think the piece about arts is very interesting because we're on the verge of an explosion of use of the NFTs, the non-fungible tokens, for digital art in particular. And even for sort of traditional art in terms of ownership. And the question will be, I think where we can see this going is eventually where those who are involved with NFTs that are art-based, is there a chance they're going to be brought in under that legislation? But I think because it's a study or a review initially, I think we're probably a year or two away from that. The information sharing piece, I thought, has been fascinating to watch because many people probably are aware that FinCEN and the banking agencies came out with a statement a couple of weeks ago on information sharing and when it should be used, and sort of broadening the scope of the use of information sharing beyond money laundering, which was the original purpose, to include different types of financial crimes. This provision certainly goes further. And one of the issues we've had in the crypto space is that it's not been used to the same extent as the banks have been using it. So, how is this going to is this going to sort of up the game, and are we going to see more crypto companies using the information sharing provisions in their activities? I think in terms of changes in thresholds, I think that remains to be seen, what the ultimate impact is going to be. Right now, the money service businesses, so the crypto industry, is playing to a 2,000 threshold versus the 5,000 on SARS that the banks play to in terms of triggering filing. We'll see where that goes. I think Andy's comment in terms of the quality or the SARS, the feedback on the SARS, I think it's a very interesting issue in the crypto space because we've heard now, I think, a couple of crypto or FinCEN directors who have commended the crypto industry for the quality of SARS that are being filed. And what I see in my work with clients is a much higher rate of interaction with the law enforcement community off the SARS that they're filing than what I've seen traditionally with the banking clients.
Yeah, just to stop you there, and I want you to continue after this, but yeah, no, we did a TRM Talks a couple of weeks ago where we had Chris Jancheski from IRSCI, and he said exactly that. There's no one better than crypto businesses in terms of working closely with law enforcement. So I think that's it's great to hear someone who's on the industry side and the law enforcement side essentially saying the same thing.
So I think those are my, for what I can make out of my notes here, my immediate reaction to several of the points that Andy had gone through.
No, that's awesome. And one thing that actually came to mind as you both were talking about art and antiquities, the Permanent Subcommittee on Investigations about, 6 or 8 months ago did a really excellent report on money laundering in sort of using high value art for money laundering purposes. And OFAC responded with some guidance of its own in that space. But the way that you're able to do a really good investigation is to trace the flow of funds. And, we'll eventually start to see, or we're seeing now, right, the use of cryptocurrency in that space as well to sort of maybe make it a little harder to do that, from a money laundering perspective, which may sort of be an angle into the NDAA, sort of on the crypto side. Andy, from my own sort of front row seat, a lot of really extraordinary people at Treasury and the components in particular all sort of came together. And not just Treasury, really the interagency. Can you talk a little bit about that process and sort of, the whole of government effort
Sure.
in space that led to the legislation?
Yeah, absolutely. It definitely was a whole of government approach. I would say a lot of it started at the top with Secretary Mnuchin. He really made it a priority, especially on beneficial ownership, to get this finally done and across the finish line. And he directed the entire department to, fall in line and really work hard to get it done. Most of that work was done within TFI, of course, but also in domestic finance. They had a large role too, because of course it's a lot of the banks that are administering these programs and filing the SARs and everything. So they were definitely involved. But TFI was definitely a leader in all of these issues, led by Sigal Mandelker when she was undersecretary. She was a really great leader, marshaling all the resources of TFI, whether it was FinCEN or OFAC, to really shore up these national security gaps to the financial system. She worked closely with the Hill. She testified at hearings and really galvanized, I think, people to work hard to get it done. And then the Deputy Secretary, Justin Muzinich, was also very integral, both in his Deputy Secretary role and then when he was acting Undersecretary. He really took this initiative and made it his priority to really get beneficial ownership in these AML updates across the finish line. He was constantly trekking down to the Hill to meet with members personally. He had congressional staff a number of times come to Treasury and sit down for half day at least with them, and with the FinCEN director too. And they would literally just talk about all the national security concerns of why we need the beneficial ownership and these various AML provisions passed. So I think between the Secretary, Sigal, and Justin really focusing on the national security aspects of these really is what got it done. And like has been said before, there was an interesting coalition of lobbying efforts to get it across the finish line too. Some folks that don't always work together really came behind these initiatives. There's business groups and large banks working with small banks, working with transparency groups, Democrats and Republicans, folks that don't always agree on a lot of things, really, I think, understood the threat to national security and to our own safety if we allowed these loopholes to remain. And so I think all those came together as a perfect storm to get it finally done. And then across the interagency, of course, the National Security Council, as you know, kind of marshals all the different departments and make sure that everyone knows what's going on and can get down to the Hill and advocate on behalf of things. So that's definitely important.
Huge lift. Absolutely. No, for sure. Carol, this is sort of the free legal advice portion of TRM Talks today. I know that's usually against the lawyers' religions, but we'll go for it here. So, obviously you're advising your clients, crypto businesses, certainly, but not just crypto businesses, sort of anyone who may have to potentially deal with beneficial ownership or some of the other provisions of the NDAA. What would you be advising clients right now? Either this is what you should take a hard look on, or this is what you should actually be doing.
So I'm going to start by saying what I'm about to say is not legal advice. Should have been a disclaimer from the beginning. Well, I think that Andy put it well in terms of there's a lot of rules that are going to have to be made. A lot of infrastructure, especially in the beneficial ownership provisions, that has to be put into place in order to bring these provisions to fruition. I was going to sort of turn the tables here and ask Andy, what he thought. This bill is obviously coming into law at the end of one administration, and there are many provisions that have to be implemented in a new administration. Any sense of what that's going to look like? Is there going to be sort of the same zeal there for these provisions, and maybe a little bit about the moving the pieces on the checkerboard or chessboard for who's going to be doing what?
That's a great question, Carol. It is interesting timing with the change of administration. And I'll also get to, there's going to be a lot of changes on the Hill as well, on some pertinent committees of jurisdiction. But on the executive branch side, you're absolutely right. With a new secretary and a new deputy secretary coming in, they're going to be the ones overseeing all this implementation. So I think it's going to come a lot down to who the suspected Secretary Yellen, who she picks to be her undersecretary of TFI, because she's going to rely on him or her very heavily, I think, to get all these things implemented, as well as the FinCEN director and OFAC director. But Secretary Mnuchin always said from his early days in his tenure that he spent at least 50% of his time on TFI issues. And I can confirm, and Ari can too, that, I mean, that's absolutely correct. His first meetings in the day and probably his last were on TFI, whether it was sanctions related or AML. So he definitely spent half his time or more. Justin Muzinich spent well over half. And so I'm sure that the incoming secretary will be picking a very strong undersecretary to implement all these things. And then but they also have the benefit that the majority of the folks are the really excellent professional career staff who will be staying from the prior to the future administration,
including the FinCEN director and the OFAC director.
Exactly, they'll be there.
Really, I think that's a huge part of this.
Yep. So there's that continuity, which is very important. All of those experts will be there on January 21st, which is very good. And real quick, just on the Hill, there's going to be a new Senate Banking Committee Chairman, Pat Toomey from Pennsylvania. So he may have some other thoughts than Chairman Crapo did. So he'll definitely be a voice to be heard. And he's already said he's retiring in 2 years, finishing out this term. So he'll probably want to, really make his mark on some areas. And so, yeah, between the administration and some of the committees, there's definitely some chairs being realigned. But luckily, there's a lot of career staff who remain.
So the bottom line is that we should all be moving along as if there's little change in what's being laid out in front of us.
Yeah, I'd agree with that. All full steam ahead.
So I guess, Ari, to your question, that's one of my biggest takeaways for clients is that we're not going to see a significant course change. So, it's important for people to understand what's in the legislation and understand sort of the next steps and be appropriate participants in those next steps, providing a comment if comments asked for in the rulemaking process, providing expertise if it would be useful in helping educate both people on the Hill and in the agencies as to what this technology is really about. And I know there's been a great deal of that effort that's happened in the last couple of years, but I think it's just we will be having changes, new faces. So some of that's going to have to be repeated and people are going to need to be brought up to speed. I do think it's important to understand what the immediate changes are. And I think probably above all, not lose sight of the fact that so much has happened in the last few months that their programs do need to be brought up to date. I am curious to, if either of you have views in terms of how the IRS is going to proceed and sort of the role of FinCEN in the examination of virtual currency businesses. or VASP, as FATF likes to call them. Does this legislation in any way help, or does it? I shouldn't say help, but strengthen the examination process? Because I know there's been a lot of criticisms over the years in that area.
Sure. I mean, my take is that, obviously, the IRS tax related issues are going to be one of the biggest issues for crypto, right, in the next few years for sure. And then on the FinCEN side, it seems to me that FinCEN has tried to be a very strong regulator in this space for a really long time. And I think that this legislation probably bolsters that role by really allowing it to sort of try to create a more robust regime around it. I know also, in addition to this bill and other AML related legislation, FinCEN is working diligently on working groups and other guidance on this topic. So I think a lot of it, to your point and to Andy's point, is this is all a work in progress, and it's really, it's for, I defer to you, but it seems like an opportunity for clients to sort of do everything they possibly can to build robust compliance programs, right?
Yeah, I'd agree, Ari. I'd say there's where for the past decade, maybe it's been a lot of focus on the Hill, on the legislative side, trying to get this done. Now that we have the bill, its focus is shifting to Treasury to implement it. So that's where all the attention and clients and folks should be looking to the actual staff within TFI that will be writing these rules, implementing, doing all these various studies and surveys that are all required in the bill.
Carol, please go. Yep.
Shouldn't forget the role of the Department of Justice, the prosecutorial arm of the government, because they've driven a lot of the meaningful legal principles that govern the space today. And I guess to both of you, do you anticipate much change, especially at the staff level at DOJ, in terms of how they're approaching cases in the crypto space?
I love how you've turned the tables on us here today, Carol. I'll do my best on that one. As a prosecutor, spent 11 years at DOJ. Definitely working a fair number of crypto cases towards the end of my time there. I think what's so interesting in the space, right, is that what you're seeing is sort of a more mainstream embrace of the technology. You have PayPal, you have DM, you have sort of things out there percolating that are going to really potentially bring crypto, and not just sort of holding crypto, but using it to buy things. And I think the more you see the use of crypto, globally, the more, concern that DOJ will have and others to really sort of think very seriously about it. I think the recent DOJ enforcement guidance was, I think, a real statement by DOJ that they take this very seriously. 83 pages of how we look at crypto. So I think that there's been some real serious work done by DOJ. I think more is coming as crypto is used more and more, in illicit activity. What do you have any thoughts on that topic?
Well, I would just add, Ari, that there was more emphasis on DOJ than are typical in some of these AML and BSA bills. There's more whistleblower protections. There was penalties for repeat BSA violators. There's various penalties for non-compliance with various reporting mechanisms. So I think DOJ will play a larger role going forward. And they were definitely called out pretty prominently, I think, in this bill.
Terrific. Before we go, and I know we have to go in a moment, Carol, I'm going to finish with you. Is there one piece of the AML provisions within the NDAA that you look at and say, this is really going to create a significant change to the way we do business, or the way, do business, looking out 5-10 years down the road?
It's an excellent question. And I probably, in the good lawyerly way, will say I'm going to reserve my judgment. I'm still in the process of going through the bill. I remember when the USA Patriot Act passed, I think it was early November of 2001, and I spent my entire Thanksgiving vacation, really from morning till midnight, working on my analysis of that. And I have a feeling that's how I'm going to be spending a lot of my Christmas vacation this year, going through that same process. I think it's more a sign of a greater understanding of the changes that are happening in the way we transact. For those who've been in this for a long time, and I was really doing digital currency before crypto, I don't see a seismic shift in terms of how the laws apply and what they apply to, but I think it's a much more serious focus. And so anyone who hasn't totally gotten it yet, now's the time to really start getting it.
No, that's a fantastic answer. I think that we're still trying to understand. We're still learning about the Patriot Act, honestly, and how to use some of the tools that are in the Patriot Act. And this will be a process. There's absolutely no question. Thank you both so much for coming on and for coming on short notice to really kind of break some news and really talk about the NDAA and this important issue and how it affects our listeners. Really appreciate you guys coming on.
Thank you.
Thanks, Harry.
This was our first TRM Talks breaking news, and you were both amazing to join me here. Promise me that you will come back and we can see how this all plays out. TRM Talks is brought to you by TRM Labs, the leading provider of cryptocurrency fraud detection and anti-money laundering software. Looking forward to another terrific discussion next month with movers and shakers from the world of cryptocurrency. Until then, thank you to our amazing guests and to all of you who work so hard to keep us safe.